Well, welcome back to the Law&Crime Network. I am Linda Kenney Baden. We are covering the case of Georgia versus the Rosenbaums, Mr. and Mrs. Jennifer and Joseph, who are accused of killing their killing their one daughter, Layla, and hurting, abusing their second daughter, Millie. They are both foster children, not that that makes a difference. Let's listen to who's on the stand now, a defense witness, Dr. Powell, trying to tell the ladies and gentlemen of the jury why the children should not be believed. Well, let me introduce my guest for this afternoon, Mike Koribanics. It is a Jersey afternoon. Mike, how are you?
Very good.
And I know you've been following this case because you and I are very interested in these child abuse cases, especially this one that we're trying. Well, we are trying it a long time because we all have our personal opinions. But Dr. James Powell is talking about how children may be suggested to, or things may be suggestive and therefore they adopt them. Why is he discussing this in this situation?
Well, I think he's mainly, the purpose of him discussing it in this situation is to show the jury that there's some sort of apprehension you should listen to the sister's testimony with. That's my feeling of it.
Well, the sister said, look, they had were need, the belts were used, the great-grandmother said they were need. If the child like Millie is saying something before even her sister died, doesn't that give credibility to her?
Well, it does, but the thing is, we don't know what led up to those statements and what she was told in the investigation, interview, things of that nature. As you know, in the State versus Michaels case
in New Jersey,
which is one of the forefronts of this, that case went to the Supreme Court, and what they found was that the interviews that took place of these children who were claiming abuse were so suggestive that there was no reliability to it. I think we have to hear a little more from this expert as to what premises he made to base his conclusion that this child might have been.
Yeah, but you know, Millie didn't see actually what happened. She said she was downstairs and her sister was dead and she was told to go upstairs. But that doesn't mean Millie saw actually what may have been, as the prosecution contends, a knee, a kick, a stop to her sister, does it?
Well, you know, that's the problem I have with this case, and we were talking about this outside before we came on the air, is number one is we have two defendants being represented by one attorney. That's a problem. Number two is, I still think the child abuse aspect of this case should have been severed from the murder aspect. I think the overflow and the overriding and spillover of those counts is very prejudicial to both these defendants. And I think that testimony should have been excluded, because a jury can easily say, well, you know what, they beat that child, so I wouldn't put it past them to kill that child. That's not reasonable. That's not proof beyond a reasonable doubt.
Well, speaking of family members that may kill, we also are going to take a quick break. But on the other side, we are monitoring for you the case in Florida where Ms. Nachtman is accused of killing her mother and her stepfather. Another family situation. Maybe there'll be openings. We'll be right back, but we're checking it for you. The prosecutor, John Terry, is going into a lot of detail about what led up to the mom shooting, and her name was Miriam, M-Y-R-A-M. The mother, the biological mother of Nicole Nachtman, who is on trial for the killing of Miriam and her husband. I'd like to bring Mike Koribanics back in. Mike, I'm a little lost right now because of so much detail. Tell me what styles people have. Doesn't mean they're wrong or right, but tell me what different styles people have.
Well, I think you're right. There's no wrong or right style, but I always think a prosecutor needs to be succinct in his opening.
Short and sweet and to the point.
I always think of an opening when I was a prosecutor as sort of like flying over the forest with the jury, showing them the lay of the land, and then as you progress with your case, you get into more details. I mean, here in his opening, he lost me at one point when he said he didn't kill her. She didn't kill her yet. Because then it's almost like, you know, what's going on here? It was too much detail.
Soundbite like you're writing for an old TV show, right? Ladies and gentlemen, Nicole Nachtman knew exactly what she was doing. She went home, killed her stepfather. She shot him in the back of the neck. She cleaned up. She wanted to make sure no one knew. She then lay in wait for her mother to come home, and then she shot her. Let's listen to how this happened.
That's
something
exactly
like that, right? Something quick.
And that's why I come here, because my next opening, I'm going to remember what you just told me.
All right. So, but again, now this, we haven't heard from the defense, but from pretrial motions, we know one thing. We know that there's going to be two different defenses asserted. One is going to be battered child syndrome to show why it was, maybe in a self-defense method or in her mind, Nicole Nachtman had to kill her mom. And then there's going to be a possible insanity defense to show why she thought she had to kill her stepfather because she may be schizophrenia. Now, I'm jumping the gun a little bit, but let's just assume that's true. How do those two defenses line up?
I think it's very difficult. I mean, you can't have multiple psychiatric disorders to explain different murders.
But here's what they say. They say the defense is going to, because of the motions, and the judge said that the battered child, the battered abused child syndrome is not a psychiatric defense. It's going to be a self-defense defense.
Well, I think once they show the GPS records, self-defense is like in the heat of the moment. You can't drive from Florida State to another place to plan your murder and then claim self-defense. I mean, we all know self-defense is only viable till you can retreat. How much further could she be if she's living in another place?
Well, you know what? There was an old saying a long time ago by a movie star who's not so credible right now, but his name was John Wayne. And the defense that prosecutors used to say a long time ago is, well, they deserved it, they had it coming. I don't think that would fly here. So this is the prosecutor in Florida versus Nicole Nachtman. He just announced, Mike Koribanics, that Nicole Nachtman said when she's talking to her half-brother, I did it. I did it. I did it. I did it. She said, whispered it, but it's a confession, isn't it?
Well, we're talking about best evidence. There's nothing better in evidence than having an admission by the defendant as to that defendant's action.
Admission or confession? Confession, right?
This is a confession. Well, it's really admission because confession only comes in a custodial territory.
All right, very good.
I study before I come and see you.
Okay.
But I think, yeah, that's what you open with. There's too much detail in this opening. And I think it's going to, I mean, it sounds like it has a really good case.
It does, obviously. It seems to me, my impression as a defense attorney now, having been a prosecutor, that he's got a good case.
So I think this should really be a bullet point opening and let your witnesses tell the story as opposed to you tell the story just in case they astray from the preview you're giving.
Yeah, so anyhow, Mike, you know what? We're going to listen to more of this trial, but guess what we have to do first?
Take a break.
We have to take a quick break, ladies and gentlemen. Stay with us at the Law&Crime Network. We're in the case of Florida versus Nicole Nachtman. Florida versus Nicole Nachtman. The prosecutor, while we were on break, finished. He said that the father, the stepfather, had one shot to the back of the neck, kind of here. One shot. His hat was washed in the washing machine, in the dryer. The mother, however, she had 3 shots. One of them was to her stomach, a painful shot, and the shooter was about 2 feet away, which means the gun end was about 2 feet away when the mother was shot. Let's listen now to what the defense is going to say to determine to this jury or tell this jury not to hold Nicole accountable. Well, this is Nicole Nachtman's defense attorney, and boy, Mike Koribanics, she has picked up the pace in terms of her expressions and all, trying to advocate for her client. But when you have a psychiatric defense or even a battered child defense, what does money do for it if there's money involved and there's evidence that a defendant may want money? What does that do to it?
I think it could cut both ways, but I think generally, and the stronger argument, is that it really takes away from that. Because when you think of a psychiatric sort of disability, you think that's what triggers the event. Once you throw money into it, it really shows that somebody had another motive other than revenge for being a battered child or as a result of some sort of psychosis. They wanted money, you didn't give it to them, they killed you.
Okay, so, but in classic battered, abused women situations, husbands or partners sometimes, or whether it's a woman or a partner, they can have money taken from them so that, you know, there's a control purse, right? You can't even get a cent, right?
Correct. But this is different, though. This is not that kind of relationship. This is a child with their parents, and the parents and child is a little bit of a different relationship, in my opinion.
Okay. So anyhow, ladies and gentlemen, we are following this. Obviously, the defense will continue their opening, but guess what we have to do? We're going to have to take another one of those quick breaks. I'm Linda Kenney Baden with Mike Koribanics. Stay with us on the Law and Crime Network, where we have 3 trials going on right now.